All right, I believe we're ready to begin. Good morning, everyone. Welcome to the September docket of the Kansas Court of Appeals. I'm Judge Thomas E. Malone. We also have Judge Michael Boozer and Judge Anthony Powell. We are the panel for the hearings this morning. We're having these hearings by Zoom. That's not my preferred method of having hearings, but that's what we're doing these days under our court's special COVID-19 rules. And I want to thank the attorneys for participating in the hearing by this method. We only have 2 cases this morning. I'll call the cases in the order of the published docket. The attorneys can enter their appearance when the case is called. I'll just make a few preliminary remarks for the benefit of the attorneys. As you probably know, we have read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your argument. As the presiding judge, I'll be the timekeeper. Each party is generally given 15 minutes per side to make your argument, unless it's designated differently on the docket. And I don't think we have any of those cases. If there's more than one attorney per side, you'll need to decide in advance how you wish to divide your time. And also the appellant's attorney should let us know at the beginning if you wish to reserve any of your time for rebuttal. After the hearing is completed, your case will be deemed submitted for decision. And at that point, the court will take the case under advisement and we will get a written decision out to you and your clients just as soon as we possibly can. So with that, I'll go ahead and call the first case on the docket. It is from Reno County. It is number 120464, entitled The State of Kansas versus Dominique O'Shea Holder. This is an appeal by Mr. Holder of his convictions of possession of marijuana with intent to distribute more than 450 grams and also conspiracy to distribute marijuana. And who do we have here for the appellant?
May it please the court. James Latta with the Appellate Defender's Office, representing Dominic Holder. And may I please reserve 3 minutes for rebuttal?
Granted. And for the appellee? You're on mute, Mr. Stanton.
Apologize for that, Your Honor. Thomas R. Stanton, Reno County District Attorney for.
Thank you. And Mr. Latta, you're reserving 3 minutes for rebuttal. You can go ahead and begin whenever you're ready.
Thank you, Your Honor. For my argument, I'll discuss just issue 1 and issue 4. Issue 1, of course, is my unconstitutionality of the statute, and I'll rest on my brief for the remaining arguments, unless, of course, Your Honors have any questions. And for issue 1, my attempt to invalidate statute 215705E, I just want to emphasize one point of the difference between the theft statute that the state relies on to say they're similar than the statute at issue here. I just want to point out very quickly that the theft statute is a very different rebuttal that has to do solely with evidence, saying that if you prove certain facts, then you have a prima facie evidence of theft. And the main difference here is we have an issue where if there's a certain amount of weight of marijuana, then an entire element is turned over to the defense to have to rebut according to the statute. And so the prima facie presumption, of course, wouldn't even rise to the level of reasonable doubt. So it's not even the same kind of rebuttal, same kind of presumption. So I just wanted to emphasize that difference between these 2 statutes. And moving on to my issue 4, which is where I argue there's insufficient evidence based on the definition of marijuana. I did want to correct one thing I said in my brief. Mr. Holder allegedly committed his crime in April 2017. And the definitions of marijuana actually, in preparing for this case, actually changed in May 2017. So I wanted to point out that he should probably, this case should probably be resolved under, I'm not sure, one statute came in effect January 1st, 2017, the definition of marijuana in 654101. So probably that definition, and the only difference between the two is that the earlier version of the definition no longer has the controlled substances that says that, you know, anything in schedules 2 through 5 don't count. So that's the only difference. But the definition is the same when it comes to the cannabis plant and having to prove that marijuana is from the cannabis plant, which we contend never happened here. Another thing I wanted to point out, there's also the exact same definition of marijuana in the distribution and possession statutes, which would be KSA 215701J. It contains the same exact definition, but for analytical purposes, I still believe that KSA 4101 AA controls because the statute specifically directs you to the Controlled Substances Act for the definition of marijuana. My next point on the marijuana insufficiency issue is I wanted to make some distinguishments from the 1977 Kansas Supreme Court case that read THC into the definition of marijuana, which is nowhere to be found. First and foremost, as I argued in my brief, I don't think our Supreme Court analyzes statutes that way anymore. We clearly go off the plain language, and THC is not found in there. I also wanted to emphasize the statute has actually been changed since then. The statute now says all parts of all varieties of the cannabis plant. And in 1977, it refers specifically to cannabis sativa. And I wanted to emphasize that our Supreme Court actually relied on that language to come up with inserting THC into the definition, because the Supreme Court said that that specific variety of the cannabis plant only had the euphoric effect. And so that's why they read in that definition. And then finally, on my insufficiency issue, I just wanted to point out that a good analogy to this would be the many cases where we have the sentence enhancement factor for these distribution cases regarding school property, where this court has repeatedly found that just saying that someone sold drugs within 1,000 feet of a school will not count as a sin, is not sufficient evidence for that sentence enhancement factor unless they meet the actual definition of that. So that's basically what we have here. We have experts and officers and even lay witnesses coming in saying, this is marijuana, I know marijuana, but they never get around to saying whether or not it came from the cannabis plant and whether or not it's not a part of the mature stock of the cannabis plant. So an analogy would be someone coming up and testifying, yeah, this is school property. I'm well aware of school property. I've been to school, but never testifying that it's actually an accredited school. And this court would not uphold that. So I think that's a good analogy for that. And other than those comments, unless this court has any questions, I'll rest on my brief.
I'm not hearing any questions, so thank you, Mr. Latta. Mr. Stanton, whenever you're ready.
Thank you, Your Honor. Going to the first issue, appellate counsel just indicated that the difference was that there was a fact issue. This is clearly a fact issue. First of all, in his reply brief, appellate counsel had talked about the word shall, but the statute itself, KSA 215705E, which is cited on page 16 of my brief, indicates there shall be a rebuttable presumption. There is no shall as far as the jury is concerned. It just establishes the rebuttable presumption. So I do not believe that the word shall appearing in that statute in any way makes this a mandatory presumption. The question here is whether or not this is a mandatory presumption or a permissive inference. And it's clearly, especially as it was presented to the jury in this case, a permissible inference. The jury has a right to either consider or not consider that presumption. There's nothing in the instruction that requires them to apply the presumption and to make a determination based on the evidence submitted. So I don't understand the argument that somehow this is an unconstitutional requirement for the jury. The jury has clearly the ability to either consider or not consider that presumption when making its determination. So I would argue that the defendant has failed to show prejudice or show that that statute is unconstitutional. And I would rely on the remainder of my argument in my brief on issue 1. Regarding issue 4, what the defense is trying to do in this case is to add more than the statutory elements. The question is whether this is marijuana, and it's a sufficiency of the evidence complaint. And so the standard of review is whether or not a jury could have found, based on the evidence presented, that this was marijuana. And to do that, you simply need to look at the chemist's testimony. First of all, the chemist testified that she had testified in Kansas as an expert, that she had literally tested thousands of samples of marijuana in her career to determine whether marijuana was present. She talked about the fact that marijuana was a controlled substance. Mr. Bravi, the defense counsel at trial, did not object to the court finding that she was an expert in identifying these controlled substances. She talked specifically about the tests that she ran, including a microscopic examination of the plant to determine its unique characteristics, and then 2 other chemical tests. She was asked if the tests are accepted in the scientific community for being accurate for the identification of marijuana. She advised they were. There was no evidence otherwise. So the question is, could a jury find that this was marijuana based on that testimony? I don't think there's a question in this case that the jury certainly could have found and did find that this was marijuana. Requiring the state to now, after all these years, start identifying marijuana as a specific product of a plant has never been required, and the defense counsel is trying a new theory to see if this court will accept that new theory and add more elements to this crime. The instruction itself, which is 57.020, only requires the name of the drug. If you look at it, it says insert name of controlled substance here. It does not say a definition of the controlled substance. And I would argue that attempting to do this will have huge effects later on. We all know that, and this is not in my brief, but this is based on some arguments defense counsel just made. The defendant in this case attempted to draw a distinction between CBD or hemp and marijuana. Over the state's objection, he was allowed to question the chemist about the nature of this particular drug. And she was able to go into even more detail based on that cross-examination of why this was not hemp, but was in fact marijuana. And that was based on the fact that there was no CBD detected. Doing what Mr. Lotto would ask you to do at this point would require would be very confusing because both hemp and marijuana come from that same plant. So the question isn't whether or not it comes from the plant. The question is whether it is marijuana. And the evidence in this case clearly showed that it was marijuana. The defense should fail on that argument. I do want to address, additionally, Your Honors, the issue number 6, because the prosecutor, in this case myself, has been accused of prosecutorial error. In defending the defendant, in this case, defense counsel picked a strategy which was to try to blame Ms. Haller for all of the drugs, for masterminding the operation. And during his closing argument, he indicated to the jury that Mr. Holder had been honest with the cops. I understand that just a statement by defense counsel does not necessarily open the door to comment by state. But in this case, that was a demonstrably untrue statement. The fact that he had been untruthful with the officers at the time of the stop was a fact that was not contested. The question here is whether the state gave an opinion as to whether or not the defendant was credible. The statement made in closing argument was, "It's not true," and that was a demonstrable fact. The statement made by the prosecutor was simply acknowledging what all the evidence showed. Even the defense presented at trial showed that they were together, in as much as in order to blame the co-defendant, he would have to admit that they were traveling together. And so that was a demonstrably untrue statement. It was a fact of the case, and it was certainly not prosecutorial error, and it wasn't the opinion of the prosecutor. It wasn't my opinion at the time. It was a fact. The second part of that argument being made by defense in this case is that the state somehow committed error because of saying that the co-defendant had accepted responsibility. Her acceptance of responsibility, her credibility was always online, was on the table. I made it clear to the jury that it was their determination, their decision to determine the credibility of all the witnesses in the case. The defense counsel cross-examined Ms. Haller extensively on her plea agreement, which was placed in evidence. So it was a material fact, and the law shows that the state did not make any kind of error or make any improper statements during closing arguments. I would rest on my brief for the remaining of the issues.
All right, thank you, Mr. Stanton. Mr. Latta, you still have your 3 minutes of rebuttal.
All right. My first comment would be in response to the statute being constitutional. So the statute sets a mandatory rebuttable presumption by its plain language. But for some reason, though, in all of Kansas, the jury's being instructed.
Isn't mandatory and rebuttable, that's a contradiction of terms, isn't it?
That's not how I read it. I read it as you must impose the rebuttable presumption, and then the whole burden switches to the defense to disprove an element of the crime. So I read the statute as you don't even have a choice. Once the state puts on evidence of 450 grams of marijuana, or just some evidence of that could be inferred as that much, then according to the statute, you have to give it the rebuttable presumption. But for some reason, though, they've been given these permissive instructions, which don't even reflect the words of the statute. So I don't think instructing in a permissive manner can all of a sudden shield off a statute from becoming unconstitutional. And even if that statute's constitutional, then the instruction does not reflect it. And that statute's the only only law that gives that instruction any legal appropriateness. I mean, there's no common law rule that says you have 450 grams of marijuana, you have a severity level so-and-so crime, so that the only basis is the statute for that instruction. And then just for the marijuana insufficiency of the evidence, I mean, yeah, it's kind of amazing that we've never, I mean, the legislature put the definition of marijuana in there for a reason. They applied it to everything in there. They also put the definition in 215701. And to me, it's kind of amazing that we've never held the state to the burden of what the legislature said they had to prove. I mean, the legislature put that in there, and as your honors all know, we have to follow the plain and unambiguous meaning of the legislature. Same way we have to follow the school property definition, even though we may disagree with it. I mean, the legislature, for many years since 1977, could have added in THC. And for some reason, they chose not to. And I think the only safe way to decide this case and to really give defendants for all marijuana cases, you know, to give them the right that the legislature gave them, I think we have to add that definition of marijuana to be proven, just like school property. That would conclude my arguments. I just ask that this court vacate the marijuana distribution conviction, ask this court to vacate at least the sentencing factor for the conspiracy distribution conviction. And then we'd also ask for remand and a retrial based on our other errors. If there's no questions, that's all I have, your honors.
All right, counsel, thank you very much for your briefs and your arguments. We really appreciate it. And with that, that concludes the hearing. Thank you.